So, good afternoon and welcome to today's program, Estate Planning 101, the basics for higher ed professionals. I'm Nicholas Cunningham, the program manager of LVAIC. We have a great presentation for you today. Estate planning attorney Kalyna Procyk from the Pollock Law Group is joining me
It's
today. Oh,
uh, Nick, it's Kalyna Procyk.
Kalyna Procyk, thank you. You see, I was in my head. I practiced it when we were off camera, and this is what happened. So thank you. Kalyna Procyk will be leading today's program. She'll break down the essentials around estate planning so higher ed employees can learn without all of the legalese. Before we begin, please be aware that we are recording today's session. Additionally, please put your questions in the chat throughout the presentation, as we'll be answering all the questions at the end in the Q&A, where we will pause the recording to respect everyone's privacy. And now I'm going to turn everything over to Kalyna, please.
Kalyna, you had
Kalyna,
it. You
I
had
had it the
it
first time.
before.
You
You
can
totally
test
had
me.
it. There'll be a quiz later. Okay, thank you, Nicholas. So hi everybody. My name is Kalyna Procyk, and I am the founder and owner of Procyk Law Group. I have a boutique estate planning practice out of Bethlehem, Pennsylvania. So before we get started, there are a couple of important things that I want you guys to have access to make sure that all of your questions are answered. So I'm going to ask Nick to put the link, that first link in the chat that says Procyk Law Clio Grow. When we're in person, I call this my purple worksheet. Obviously, it's not purple online, but if you click on this, this is going to enable you to follow along with the presentation, click the things that are relevant to you, and at the end, there'll be a gift for you if you fill this out and turn it in. So I do encourage you guys to click on it and fill it out as we're going along. So as Nick mentioned, this is Estate Planning 101, Basics for Higher Ed Professionals. If you ended up in this Zoom room for a different reason, that's okay. Welcome. My intention is for you guys to get a lot of value out of this and to learn something about estate planning. So today we're going to talk about estate planning. I'm going to tell some stories, and then we'll have some time for Q&A at the end, maybe 10-15 minutes for Q&A at the end. So yes, please, number one, be sure that you click on the link to the purple worksheet. All right, so this is me and this is my why. How did I get here? I started off as an attorney in the Chicago area. I'm originally from Chicago. I'm a transplant to the Lehigh Valley. My husband got a job here a little more than 10 years ago. And so he's a professor at Lehigh. He's an art historian. For those of you that may be on this call from Lehigh, he's got a job here, passed through the whole tenure system. And so now we're here for good. We're rooted here. And so originally from Chicago, worked for a couple of very large law firms there. Always knew I wanted to have my own practice. And after Nick got tenure, decided to put down roots and open up shop here in the Lehigh Valley. So before then, I spent a little time at Muhlenberg. I ran sustainability programs there, taught a little for Muhlenberg, a little for Lehigh as well in political science. And so I'm really happy to keep the connection with LVAIC and with the various schools. I have a lot of clients that come from the world of professors or administrative professionals. There are some interesting tweaks to estate planning for this group of people. And so if you have questions as we go along, I just want you to drop them in the chat. So on the photographs here, you can see our daughters. This is Thaisa and Liana. They're at this point they're much older and more glamorous than they were in these photos. Now they're 17 and 12. The folks here on the right, those are my parents. This is them in their backyard in the Chicagoland area. You know, my dad's still alive. My mom passed away a few years ago, and she was actually one of the reasons why I ended up specializing in estate planning. Because I'll tell you, when she passed away, my parents, at one point, they were very organized. They were on top of things. My mom owned a business. They thought they had all their papers in place, but when my mom passed away unexpectedly, we pulled those documents and realized that there were so many gaps in them, and they actually created a lot of problems for us. And so consequently, I needed to fly to Chicago, leave my husband and my two kids here in the Lehigh Valley, and help my dad settle everything. And even though my brother and sister and we get along very well, in the wake of a death, there was a lot of fighting. And I knew that a lot of this could have been avoided with some pretty simple planning. So that's one of the reasons why I do what I do. I try to take this and pay it forward and help other people avoid the exact same situation that I found myself in with my family. So who is this for? If you want to make sure that that you're not going to leave a mess for the people that you love, this presentation is for you. So I want you guys to take a second to think about, why did you come here today? What motivated you to come to this webinar? Maybe it's because you want peace of mind. You wanted to be sure that your family had the comfort and insurance of knowing that everything would be okay if something happened to you in the event of your death or incapacity. Maybe you wanted to be sure that you knew what would happen to your assets at your death. Maybe you're concerned about taxes. You want to be sure that your family doesn't pay estate taxes or death taxes unnecessarily. Or maybe you want to be sure that if you ended up in the hospital, you'd be taken care of in the best way possible, and the best decisions would be made for you. Maybe you're interested in supporting your community, and you want to be sure that some of your assets or your important stuff ends up with an organization that you care about. So I want to let you guys know that if you came for any of those reasons, you came for the right reasons. So today, what we're going to do is we're going to talk about some of the main topics that I encounter when I'm talking to people about estate planning. So you have a sense of what may happen in the event of your death or incapacity. So the first thing I want you guys to think about is, who will step forward? Okay, let's say you were in a car accident and you were knocked out, you ended up in the hospital. Who would be the one to raise their hand and step forward and say, hey, I will help. I'll help make decisions about your health. I'll help make decisions about your bills and your house and your assets. So I want you to take a second and think about that. Who would be that person? And maybe for some of you, you say, oh, that's my spouse. Well, okay. What if your spouse is in the car with you and they're in the hospital as well? Who's that person that steps forward? Now, I want you to consider, that person that you know will step forward, maybe it's your neighbor, who, you know, you're close with, is, or maybe it's one of your siblings. Is that the person that you would want stepping forward? Is that the person that you would want to be serving in that important role? And I'll tell you, that distinction is very important, and you're going to see that in a lot of different places during our conversation. Um, the person who would step forward may not be the best person, and really, whoever you name in that person, in that role, whoever is in your heart to as the best person to make decisions, that person is going to be better than the default. So the first issue I want to consider is, when was the last time you reviewed your existing plan? Now, there are two answers to this. Either you have an existing plan, or you don't have an existing plan. Usually when there's an existing plan, you should be getting that plan reviewed every 5 years or so, because you guys, you're in the thick of your lives. A lot of things are happening. People are being born, people are passing away, people are getting together, they're getting married, people are separating. Perhaps you're purchasing new properties, you're selling properties, maybe you set up an LLC. All of those things can have an effect on your estate plan. So most of the time when people think about estate planning, they think about the documents. They're thinking the will, the power of attorney, the healthcare directive, the trust. So they're really focused on the documents. But estate planning, that's only a very small part of estate planning. Okay, estate planning is actually, when it's done well, and the way that we do it, it's holistic. Okay, so it covers a lot of different topics and a lot of different territories. The documents are just the product of our conversations, and where you identify the things that are possibly unknown unknowns. The documents simply memorialize all the decisions that you've made. So I'm not even crazy about the term estate planning, because I feel like it's too focused on the documents, and it's also focused on people's death. So either you have an estate plan already, or you don't have an estate plan at all. You don't have anything in place. And if you don't have anything in place, then the state has a plan in place for you. And if you become incapacitated, that's the process of guardianship or conservatorship. And if you pass away, that's a process that's called probate. So we're going to talk about those two things in a second. All right. So again, one of the things that I don't like about even the term estate planning is a lot of the ways that it's done traditionally is really planning for your death. It's really focused on the end of life experience. And sometimes what happens is you have a one-time transaction with an attorney. Maybe that attorney is also helped with your kid's DUI, or does some criminal work on the side, or real estate closings. They do a little bit of everything. Or sometimes you go to a big firm, and ironically, sometimes you have the exact same experience, whether it's a really big firm or it's the guy down the road that does a little bit of everything. A lot of times it's a one-time transaction. You can call them and say, hey, I want some wills, and they'll email you wills. Maybe those things avoid probate, maybe they don't, maybe they avoid some of the estate taxes, maybe they don't. But one of the issues is, and now with AI and and LegalZoom, a lot of people think, oh, I'll just go on LegalZoom and I'll draft some things up. The problem with that is that you guys are not experts in estate planning. Why would you be? You're experts in the things that you're experts in. And instead, and there are many unknown unknowns that don't even get surfaced until we start a conversation and we can really get at the root of what your family dynamics are, how your assets are owned, where they are. All of those things are really crucial to holistic estate planning. So as I said, a lot of times estate planning will be focused on death. I'll give you one example. Friend of mine who's an estate planning attorney, she had her dad had set up an estate plan, and he had a trust set up. Some things were going to his wife, other things were going to his children. And then, time passed. He passed away. The kids unearthed the estate plan and thought, okay, well, phew, we know he had an estate plan, so I'm sure everything was taken care of. Well, he had planned for his death. However, he did not plan for life to get in his way, because during that time, the woman that was his wife became his ex-wife. And so, the kids and the ex-wife then were embroiled in a really nasty struggle, because there were some things that contradicted their divorce decree and other things, because he just figured, oh, well, it'll just, my estate plan is set for my death, and it'll flex with whatever happens during my life. That's actually not true. So one of the things that we do at the firm is we'll review your estate plan with you every 3 years. We check in with you every 3 years, because there are things that might happen that could affect things. So if you go into your the purple worksheet, so that's that link that Nick had put into the chat. Go into the purple worksheet, and on that worksheet, check. If you have a plan but you need to review it, check that on the purple worksheet. Okay, so we do things a little bit differently. We're trying to plan not just for your death, but actually putting things in place that are going to help your life. So making sure during the estate planning process, making sure that you're more financially organized than you've ever been before, making sure unclaimed property doesn't end up with the state, and making sure that if something happens to you, your loved ones have someone that they can go to and rely on, which you're definitely not going to get with LegalZoom. With me, they always have somebody to contact, and then we'll make things easier on them. Okay, so I had told you we're going to talk a little bit about what happens in the event that you don't have any documents in place, or your documents are so old that they're basically worthless. They can't be used. So the state does have a plan for you, and if you become incapacitated, it's called guardianship. And if you pass away, it's called probate. So what happens in guardianship? You end up in the hospital for some reason, you're unconscious, you can't make decisions anymore. If you don't have a power of attorney document where somebody can serve as your legal agent to make financial and legal decisions for you, then someone will have to go to court. And that's even in the case of your spouse. If you have assets that are not held jointly with your spouse will then have to go to court. So somebody will raise their hand and say, hey, I will take care of this. And that might be someone that you want, and that might not be someone that you want. Or maybe you have 3 kids and 2 of them step up and go to court and say, hey, I will take care of this on my parents' behalf. Um, then at that point, a judge will need to decide whether that person is a good option to serve as your agent. Now, a judge does not know you. A judge doesn't know your family dynamics. A judge doesn't have uh, the full picture, and so consequently, a judge may make a bad call. So there was a case a colleague was telling me about out of Arizona where there was an elderly man. He had a son in a different state. The son was in California. The son had opened up a couple businesses and then had to close them due to debts. So his credit score really took a hit. He did not have a good credit score. And the son came in to take over guardianship of his dad because they were concerned that there was a caretaker that was committing elder abuse. And the judge said, "Well, no, I'm not allowing you to do that. You're not a good financial bet. Your credit score is too low." And so instead, the judge appointed a private company that was used money from the dad's assets. So the dad needed to pay this private company to serve as his agent when his son was right there and would have done it for free. So point being, whoever you name as an agent or a decision maker for yourself is going to be better than whoever a court names. So that's if you're incapacitated. If you end up dying, the process is called probate. Okay, and you guys may have heard about probate before. Some of you may have been through probate with a parent or a family member. Now, why don't people like probate? There's a lot of talk about avoiding probate. Okay. Well, first of all, what is probate? Probate is a lawsuit that gets filed at the time of your death, and that shepherds all of your assets and allows those assets to be distributed. Okay. Informally, we say it's a lawsuit that you file against yourself with your own money for the benefit of creditors. So it's not for your benefit. It's not for your loved one's benefit. It has historical roots in existing so that your creditors can get paid back. So the first thing that people don't like about probate is that it's long. So it can take anywhere from 9 to 15 months at minimum. And during that time, those assets are frozen. So they cannot be distributed to your heirs. So if there is somebody that is relying on those funds or would need access to those funds to be able to, say, pay the mortgage on the house, or maybe you're supporting someone, maybe there are kids in your life, and they would need that money for their college fees, they will not be able to get access to those funds until the probate process has concluded. So it's long. There's also a lot of bureaucracy involved. So whoever is left would need to hire an attorney. They may need to show up to court. There are many hoops that you need to jump through. And especially for people that have family out of state, they're not local. Even if you do have people that are local, that can be burdensome and onerous for them. Additionally, probate can be expensive. So we usually say that the cost of probate is anywhere between 2 and 8% of the value of the estate. And, for estimates, we can take 5% as a midpoint. A colleague of mine the other day was telling me about one probate. The only thing that was in the probate was a house, and the house was worth $1 million. So executor fees totaled 25,000, and attorney's fees ended up at 35,000. And then there was an assortment of other kinds of administrative fees. So that's a considerable amount of money. That's $55,000 at the passing of someone. $55,000, that's not a small sum of money. That's college tuition. That's a down payment on a house. That's a couple of weddings. So the cost involved, that's another reason why people do not like probate. Also, public nature of probate. So most people don't realize that if your assets are going through probate, that lawsuit is filed in county court. So if you know people that have passed away, maybe your family members or your neighbors, you can go down to county court, the county courthouse. You can pull their will if they had a will, and you can see who got what. So some people care about this, other people don't care about this. There have been a bunch of celebrities who only had a will, and so their assets went through probate. JFK Jr., John Lennon, Babe Ruth, this is Jackie Kennedy Onassis. All their wills are publicly available. So if this is a concern for you, if you are concerned about your assets going through probate, for whatever reason, on your purple worksheet, so purple worksheet, you can get to that. The purple worksheet, it's actually not purple, but on your worksheet, you get to that by clicking that link that Nick put in the chat. Open that up, and on that worksheet, click, I want to keep my family out of court. Okay. So another issue, how do your kids or your loved ones take the assets once you have passed away? And there are a couple different options here. Either they receive those assets outright and unprotected, or they are able to receive the assets with asset protection around them. And so here on this slide, you see a lovely, creative young woman who perhaps if she received an inheritance of a lot of money, maybe she would spend it all on her band, or go take a trip when her parents would prefer that she invested that money or saved it, or took it and went to college. As you guys especially know, working with young adults, at age 18 to 21, 18 to 25, all of their neurons in their brain have not concluded making all of their final connections. And sometimes they make some very impetuous decisions. So let me tell you one story that a colleague told me, sits with me. There was a couple with 3 children. They had divorced a long time ago. There were 3 sons, and the dad passed away, and he left $500,000 to each of the 3 sons. One son was 18, one was 24, the final one was 26. So 18-year-old inherited $500,000. He was in college, promptly quit college, said, I'm moving to Bali to find myself, and did just that. So his mom, meanwhile, was just desperately trying to get him back, just, hey, finish your education, finish college, then you can go take a gap year or take some time for yourself, but stay on track during this really tumultuous and volatile time. So he got that. Then child number 2, son number 2, was 24 years old, promptly proposed to his college girlfriend. They bought a house in Connecticut for cash for $500,000. 2 years later, those two are divorced, and the wife walked away with half of the house. So there was no, there was no asset protection around that was lost to the ex. Then child number 3 was 26 years old. He already had had a problem with drugs and alcohol. He was dabbling in that. But with the addition of $500,000 on top of it, and in his grief about his father's passing, he just, just how to put this, overindulged in some of those substances in a way that was really dangerous. And so sometimes if someone gets an influx of money at the wrong time when they're not able to deal with it, it's like throwing fuel on a fire. Whatever problems were there just get inflamed. So if this is a concern for you, you want to make sure that your kids' inheritance are protected from future divorce or litigation or bad decisions. Click that on the worksheet, or write that in the comments. I think it'll say, I need a plan for my young adult children, or I need to make sure that my children's inheritance is protected. Okay, so I'm just going to speak very briefly about this, but even if you have a will, your kids, if you have children under 18, or maybe you have grandchildren in your life, this is really, really important. So making sure there are guardians named, okay, in your will, and making sure there are guardians named outside of your will, in a separate guardianship document. So this is one. I'm just going to leave you with that. Guardianship, very important. Second, temporary custody or temporary guardianship. A lot of people don't realize that if you have small children and you go on a date with your spouse, you guys are in a car accident, and maybe the kids are either with their grandparents or a babysitter, at some point the police will be called. And when the police come to your house, if there isn't a guardianship document or a temporary guardianship document with the person that's watching the kids, those kids will be taken into protective custody and will be held there until custody is established. So that might be a couple of days, maybe longer, but in the event something happens to you, that's a really big risk, that your kids would end up in foster care when there are, I'm sure, people that would love to take them for a couple of nights and just be a loving, supportive presence. So temporary guardianship, very important. And if you are concerned about this, mark on your worksheet, I need a kids protection plan. How about your healthcare directive? Okay, and is it going to work when you need it? So in Pennsylvania, we had a really big revision to our power of attorney legislation and healthcare legislation around 2014, 15, 16. So things that are older than that, in a lot of instances, they will not work. Back in the day, our living wills and our power of attorney documents used to be one page. They were just one pagers. Nowadays, if it's a one pager, a bank in a hospital likely will not honor that. So maybe you guys have heard the story of Terry Schiavo. She was a young woman who at age 26 had a heart attack and was in a vegetative state. Terry's husband petitioned the court to allow him to remove the feeding tube and let her go. They had had conversations about this, and Terry's parents said, no, absolutely not. We think she's going to wake up. So for 10 years, Terry Schiavo was attached to various tubes, and she was being kept alive by those tubes, and she did not wake up during that time. So her husband finally, after 10 years, won the court case. There was litigation going on the entirety of those 10 years, and they allowed him to remove the feeding tube. And after a few days, she was allowed to peacefully pass. But this entire situation could have been avoided if she had a living will, and if it had been clear to her loved ones exactly what her wishes were. Okay, so a few planning techniques that that are really common but are problematic. Okay, so one thing that I'll see all the time is people owning property jointly. And you'll see this a lot with elderly parents. They say, "Oh, I'll just put you on the deed. We'll avoid probate. I'll just put you on the deed." So sounds good at the time. This is a quick and dirty solution. It entails going to an attorney and changing the deed. However, the problem doesn't start there. Or the problem does start there, but you're not going to feel the effects of the problem there. The issue is, if it's a home in the Lehigh Valley, maybe the parents bought it for $100,000, and now that same home is worth $600,000. So, the mom will pass away, and the kids will inherit. If they're on the deed, let's say the daughter inherits the house. But when the daughter goes to sell the house, she will have retained the mom's basis on the gifted property. So the basis, that's the value of that property for tax and capital gains purposes. So if mom bought the property for $100,000 and she gifts it to her daughter, then that daughter retains that $100,000 basis. And then when she goes to sell it for $600,000, she has to pay capital gains on the difference. So she has to pay capital gains, which can be 15 or 20% on the difference between $600,000 and $100,000. So that's why owning property jointly can be problematic. Sometimes people will say, well, how about beneficiary designations? I can just, put someone on as a beneficiary. Okay, there are a couple issues that come up with that. One is if you have somebody as a beneficiary and then they pass away, then it kicks the whole thing back into probate. You're not even thinking about it, but it'll kick it back into probate. Also, with beneficiary designations, usually they give you, a couple of slots. They'll say, oh, who do you want as your beneficiary? But when that if something happens to that account, for example, your account is with TD Ameritrade, and then they get bought out by Charles Schwab. Well, those beneficiary designations are not transferring with that account. So that might leave a big gaping hole there. And third, with beneficiary designations, sometimes people say, okay, well, I have 3 kids. I'm just going to designate beneficiaries on all my accounts to my 3 children. Well, then at the time of your death, if there are, if someone needs access to some funds to settle up the estate, let's say to fix the house so they can then sell the house and split it 3 ways, there is no money to be had. There's no money that can be used to front those costs. And then whoever's in charge either has to go to their siblings and say, please, can you give me back that money? Which is a really hard conversation to have. Or they have to front the money themselves. And sometimes that piece where they're fronting the money themselves can be very, very painful because then they'll have to wait the 15 months to get paid back. So signing a will, people sometimes think that having a will that will avoid probate. No, that's not true. A will go through probate, or if you have a trust, relying on a trust schedule. Also, trust schedule is not enough, and we'll talk about this in the next slide. So the one structure that we have that reliably avoids probate is the structure called the revocable living trust. And you guys may have heard of this. Usually when people pass, either they have a revocable living trust or they're relying on wills. So the thing that will avoid probate is a revocable living trust with disability provisions. So a trust is like a shopping cart. While you're alive, you push that shopping cart and you put things in that shopping cart. You put your home into the shopping cart. Maybe you put some accounts into the shopping cart. Maybe business interests go into the shopping cart. Then if something happens to you, your loved ones are able to step in and continue pushing the shopping cart. There's no delay. And so especially in the event of your disability, that is a very smooth transition. In the event of your death as well, it's a very smooth transition. So it allows your loved ones to avoid probate and instead administer your estate privately and outside of the court process. So, but a trust requires some extra steps. So you do need to make sure that the trust is, as we say, fully funded. So the deed transfer has been made. The investment accounts are retitled. Okay, so we talked a little bit about asset protection. Asset protection, you can also give asset protection to your spouse, not just your kids, protecting them from, divorce or their own bad decisions, but you can do that for your spouse as well. Create asset protection trust for them, which then avoids, a situation if both of you are in an accident together. One person passes away, the other person has a traumatic brain injury and decides to go and run off with the trophy wife or pool boy. They have a complete change of character. In this way, you're able to protect those assets for your kids. All right, I'm going to click through a couple of these quickly so that I can get to some other good information here. How about estate taxes? So right now, the federal estate tax exemption is very high. It is at 13.99 million per person. And next year it's going up to 15 million per person. So that's 30 million per couple. This is very, very high. But if you have an estate that has more than that in assets, anything above that is going to be taxed at 40%. Back in the day, 15 years ago, it used to be down at 2 million. At one point, it was down at $500,000. So this number goes up and down. It is important to keep your eye on this. In Pennsylvania, we have an additional tax. It's called the inheritance tax. Inheritance tax. We are one of 4 remaining states with an inheritance tax. New Jersey is another one. If your spouse inherits, it's 0%. If your children or grandchildren under 21 inherit, also 0%. If your children or parents that are 21 and over inherit, it's 4.5%. Siblings, 12%. And anybody else, nephews, nieces, your neighbors, step grandchildren, those are all 15%. So if you have a tax situation that where you are looking to avoid death taxes, click on that worksheet. I need to avoid estate taxes. Okay, unclaimed property. So right now in the state of Pennsylvania, we have between $2 and $3 billion in our State Department of unclaimed property. A lot of these funds have gotten there because people have passed away and their loved ones did not know where to find those assets. They didn't even know they existed. Maybe you have a life insurance policy that your grandparent took out on you and no one else knows about it. Or maybe you have a bank account that you use to open up a mortgage or a credit card and it's still sitting there. Or you have something else that only has your name on it. If you are not financially organized from an estate planning perspective, this money could get lost to the Department of Unclaimed Property. So if this is you're thinking, boy, my loved ones don't know where all of my stuff is. Click on the worksheet. I need an asset inventory. Okay, and then insights, values, stories, experiences. A lot of traditional estate planning does not even touch on this, but I think this is so crucial. I think this is actually the meat of what people want when they think about what will happen after a death in the family. They want those memories. They want the insights and the values. And actually, they've done some social science research on this, and people would prefer to have the memories and the spiritual and humanistic resources versus the money, believe it or not. So anyhow, at the firm, we actually will do an interview with people at the end of the process, which is usually very well received. Another thing I want to touch on is personal property. So for the academic crowd, for people that are working in higher ed, a lot of times you might have some personal property that's associated with your research, or maybe with a very specialized library that you put together that either has financial value or it has a lot of meaning to it. If that is not somehow captured, unfortunately, what I have seen is either that stuff, the loved ones don't know that it's valuable and they just throw it away, or they donate it to Goodwill, or they just, leave a note, hey, donate this to this university library. But if you have not made that agreement beforehand with said university library or wherever you think it should go, that can cause a lot of problems because it can get rejected on the back end. So I have a lot of thoughts about this. So if this is something that's an issue for you, write that in on your worksheet. Okay, so how do you start addressing some of this, and how do you make sure that you have a plan that works? Well, what we do and what I do at the firm is when we work together, the first thing we do is we set up a meeting, a working meeting, which I call a life and legacy planning session. It's a 2-hour session, and we go over a lot during that session. So we go over your inventory of assets. We talk about your family dynamics. We talk about your goals and your values. And so this is where we're going to really get into the meaty discussion of what your plan is right now, and what any gaps are in your existing plan. Okay, here I talking a little bit about how things, we talked about this earlier, how your DIY planning can leave you at risk. So, and in a second, I'm going to give you some incentive to, to also move forward, because honestly, the biggest barrier to estate planning is people themselves. And I know this for myself. It took me a very long time to put together my own estate plan with my husband. Estate planning can raise a lot of uncomfortable feelings. You're thinking about your death and your possible incapacity. And so in a second, I'm going to give you an incentive to get over your own internal procrastination, to take the first step. So here's a slide on what does it cost. So people are always curious, what does estate planning cost? So usually the cost of this life and legacy planning session is $750. If you have existing documents that you want to have reviewed, then it's $950. And typically our fees for plans will range somewhere between $2,500 and $8,500 on average, but you are only going to choose a fee that makes financial sense for you, that's more affordable and is going to save you more money than doing nothing. So here, this is my gift to you for coming to the webinar and for sitting through this information. This is a golden ticket for $1,000 of estate planning services. So I mentioned before that the cost of the life and legacy planning session is usually either $750 or $950. I will waive the cost of that session if you do three things. Okay. So I'll waive the cost of that session, plus I'll give you $250 towards any planning if you do three things. One is that link that Nick put into the chat. And Nick, if you could just drop it into the chat again, so that if anybody showed up late, they can fill that out. So one is fill out that worksheet and submit it. Number two is schedule an appointment with me. So you can either schedule, if you want to come in and you want to talk to me and get your plan reviewed and go through the 2-hour life and legacy planning session, then Nick, can you drop the second link in your in the chat? Go ahead and set up a life and legacy planning session. I think that there might be one place left for November. Maybe there are a couple spots left for December, but January is really there are a lot of spots left if you want to grab a spot in January. So first, send in the worksheet. Second, schedule a session, or go to my website and schedule a 15-minute call with Lizette. If you're not quite ready to do a life and legacy planning session, schedule a 15-minute call. And then 3, do the homework beforehand. So there will be a link to homework, and that homework is your key to getting super financially and practically organized for estate planning. So that is the third thing. And then you will get this golden ticket. So I highly encourage you to do so. So if you really have no assets, and you're clear on who you want in every role, send me an email. I think Nick is going to send a follow-up email with my contact information. Send me an email and I'll get you some resources on DIY. If you really don't have assets, but you want to make sure that the few things you have go to the right people, and you have a whole slew of local decision makers that you can tap into. Okay, so I'm just going to put this here, and then let's see, chat. Okay, so I'm happy to answer questions.
Yeah, so before we get to the Q&A, because I just want to pause it so people can talk a little bit freely.
Yep.
I just want to thank the Procyk Law Group, Kalyna, and specifically for such an informative presentation. So now I'm just going to pause. I'm going to stop the recording, and now we're in the Q&A section. All right, just waiting for it to pause.